Chema Wontumi okodema o medemo Kumasi o. Baby apoda e de betum. Mu bi umetena santimemu say ye MPP form nipa bi agimi mu a. Moni bete no na mo ankasa no ye de mu kotum. No kre onka nkyere mu e na mo so mu musansa. Mo so na matemotu bini na modi. Na mo di party na chi. Mo moditi Wontumi radio ne Kesbin FM ne MPP for radios no. Ana mo ntintam we na mo fa nkyere nkofo no mo ankokan. Sankrata we ye wie court anam akọ de be mamo na ma be kan akire Ghana for the judge ne kan ye enu ano no interpia ku bi de o se o corridor the services onye Wontumi lawyer biem e na onya akonta mining lawyer biem kwa me ntwi de we dwane ntie ni be kwa me ntwi wo Accra High Court dismisses Andiapia Kubi's application to withdraw legal services for Chairman Wontumi in Samra Boy case. Yes, see, and in some way, no, mudodo no, mon sheda enya but oh say, they be am catch Ghana for more fee near bruchi. Asamoba, look for the right source and follow the document, the information. Obetia see. The Martin Yan say, Apia Kubi say, or onye Chairman Wontumi lawyer be last week Friday, me catch them say. Say Chairman Wontumi lawyer kase onye Chairman Wontumi lawyer BMA. It's got nothing to do with the court. No. It is an agreement between the client and the attorney or the lawyer. That's it. The court has nothing to do with Chairman Wontumi lawyer, especially when the case has been exhausted. The court has nothing to do with it. Say, and the Enra ye share a year for a Tunisia for Abra Omubo World Cup no. Tunisia for Apamu Omu coach and then it's got nothing to do with FIFA. Tunisia, any coach, Omu agreement Omako that he can be fired at any time. So it does not affect the FIFA tournament. It's the same as in the courtroom, especially to say, yeah, ball, yeah, finals, and I bought a tournament. Now you bought game with FIFA just a 90 minutes plus extra time and added time. Now you bought ball in the Now you bought added time no so account. You game na afi what ba catch a FIFA say. Now also ye changes be. You have 5 options also ye changes 5 ring about all your 40. All protects say identity. But that decision was up to you. It is at your mercy. You make those decisions. So obe change 4, obe change 5. FIFA say we have 5 slots. Make those changes. It will decide so use 1, and now 4, and now 5. It is at your own what advantage or disadvantage. So that got nothing to do with FIFA. And this is what is happening right now with this Apia Kubi and Chairman Wontumi issue. No, it is simple as that. And the major idea or plan behind this is that they want to delay the case. Omnim say court no any the judiciary any lawyers some call break, and they want to find ways to delay Chairman Wontumi judgment na ebano. But something happened in court today. Something happened that most media houses did not take their time to explain to Ghana for. And many would say ayesade we ama mo amu Kumasi asante for mu di MPP china ma bon na mu nsua de na mo sori a mu mubi mu nkura sese am de ti Wontumi no mo da mo mbeda da mo ana mo behwe no na mo mpanifo nyina ya che o magum e won kran Chairman Wontumi okodema o medemo Kumasi o baby apoda e de betum eni sa mo betena mo mubi betena Kumasi mo bi mo betena santimemu say ya MPP for ma nipa bi agimi mu a mo ni bete no na mo ankasa no ye de mu kotum obi antan obia but matena wa ma eye party no nokre onka nkyerem e na mo so mu musansa mo so na matemotu bini na modi na mudi party na chi nti mo dodo no omo musa mo asai mo adwene wo fom na ma medwedwe bibi mu nkyerem team stay with me and Apia Kubi say or court akoka kire judge ne say ono Apia Kubi onye Chairman Wontumi lawyer biem. That's fine. Now okopie court dey na see judge no etie Apia Kubi asem ena sa particular asem we Apia Kubi di buy no judge no rule was so. Now you see court no dismiss Apia Kubi asem or the buy just say asem or the buy nyanse nim eningina so nti court anje antum Apia Kubi call court ko ka kire judge ne say me ne me client ne enya adwuma biem ena judge ne say asem we dey say emfa court ho say o client today another lawyer beba or the day beba o client asem media what I know and they say the woman nim no eno na me di ho adwuma nti ono client cool so client akofa o girlfriend o so ono client akofa o big girlfriend ya bobi I don't that it's got nothing to do with the court. Now they see o court ni judge no rule and that ruling me be kan akere me wi na ma kere bibi o ruling nim. Remember as way a Samurai Boy case win on the 3rd of July and a judge in the judgment beba. Remember Oba on the 3rd of June no and Okache say on the 3rd of July no and yes or the judgment beba. So technically 1 month. All right. Now so technically as samna e wo court and ye di awie ya kan wie evidence that judge nanim no ene na ohwede atro no ho judgment. So won't be di for ana on di for it is what is before the judge. It is not about the lawyers. What must I say? Now, judge, you know, or dismiss appear could be a summon deno. Mammy ready, dear Okan Yankasa, sa, dear a sea or court in there. Ninjina so, send a bay out to a mamma Quasiabintina Wontumi, Quasiabintina Kesbin, Quasiabintina radio Fubiso and Kanchra was say, or Tiasasi radio, Quasiabintina Metro TV Cassa or your Polarometry. Not on that dial because at the Adan and Mamudu Duono, at the end of the day, Kwasi Ampay this up to make a two for say Kumasi International Airport, International Kumasi Airport, International Airport. San Kwasi and Ada when a Budi Chireno Mumudu Amugas and Timemuno, Munsia Dian Kinkain, Emma Mukain Musan Samono, and Nama Kwasi Ampay this up to be about Kumasi, Ebeku two for us, and you could see Kumasi Airport, International Airport, no, because Mumudu Duan Jimmy, Mumusan Sam. Yen record. We muna. Ntiminya den. Go we dey give you, we make you for rough. This is what happened in court today. Mami biem na mjujum na Ghana fo hu. Ansa na kwasi ebe ka say, "Sade we, mo amoditi Wontumi radio ne, Kesbin FM ne, MPP4 radios no. Ana mo tintan we na mo fa nkire nkofo no mo ankokan." Baje tumi awie no, enso me sanye mo dwuma mamo. Mo gimi de. Sankrata we ye wie court anam akọ the be mamo na ma be kan akire Ghana for the judge ne kan ye enu ano no na afei mo ken kan bro for na mo dwudwum me san wini power and protect NDC 42 years na me san ye mo dwuma mo gimi NPP communicators no mo dwuma ne san Wontumi ken kan jejirem. This is simple. Why are you people making it so complicated? Mo me anko kan dey see o court in there. Now in the Superior Court of Judicature, in the High Court of Justice, Criminal Court 4, held in Accra on Monday, the 15th day of June 2026, before Her Ladyship Audrey Kosuvi Tay, Justice of the High Court. Now, case number CR004/2026, time 9:02 a.m. And Nanopa and Sebio Omo Echo Court on this matter, certified true copy. Now, the Republic versus Bernard Enchubo Siakon, Kwame Entry. Nipa 9 nipa miensa na charge omo ba ko adwane. Samurai Boy case no. Bernard Enchubosi akochema Wontumi ye charge no. Kwame Entry at large what the waka buying boom woko. Kwame Entry ne hu no. Ena aya akonta mining company ye cheba Wontumi dia. Mo MPP for munni madwuma me san be madwuma na ka tell say amenya moden. Now mame dwudwam accused persons A1 presents and represent A3. Now, Mamenkai ruling. Inti appear could be court the judge ruling nie. The Gina so or the conclude assembly so dismiss it. Appear could be some person chairman want to be lawyer no. Judge say ninja so fako. Mamenkin kind of jum. Well, simple. Ochina monkin kind of radio engineering people for Jimmy. Now, ruling before the court is a motion on notice for leave to withdraw legal services for first and third accused persons. You see, before the court, no, enkrata that way a free appear could be no, enkrata a lawyer or representative chairman Wontumi any akonta mining. Why me entry they were done into only lawyer. It appear could be there or say or withdraw the services. Onya Wontumi lawyer biem and onya akonta mining lawyer biem. Kwame entry there we done into any baby Kwame entry wo. Inti aka se nyina se Kwame entry dwane. Kwame entry What in one buying boom, you will be on now. Come here, Jesus at large. Now, come here, Jimon can once them. No, but Jimmy too. Now, I have also listened to learned counsel on both sides on objection raised. I have also considered the applicable law. Now, it is the considered opinion of this court that the instant application is a surplusage. It's a surplusage in the sense that there is no procedural requirement for a lawyer in a criminal matter to file an appearance. In much the same way, there is no such procedural requirement either under the criminal and other. Kevin, where the one change my antiasia, a buofun. So I do to water, now, oh, Baman Twaswa. O Twaswa, Quasia for Abanum, where the Kevin and Jemma antiasia, a buofun, natural matem. Now, O Twaswa will say offenses. Act 1960 at 30 or by judicial precedent that I had come across that a lawyer who has decided to cease to act for his client in a criminal matter must seek the leave of the court to so withdraw. Judge say, "Can tell that the demon hune de e ya de bi kropa etwa na kumem etwa ne yam sebio e ya sembia eye na adwemu sekrene se enne asem wo court na lawyer onim mra onim se sebio court mratie na sa lawyer ne ono ne client enya problem na lawyer no na adwene ye de se obetumi aba court na obeka kire court se nipa na meye ne lawyer no meni na gya adwuma ye o se ohu ne se engineer so bia ni so in fact wohwe Ghana mremu a we ya de a ewosanka eye den apia kubia ono de sa moshi we ba na eti ase se engineer so bia ni se ewose oba court kura be krame se me ne me client eye chema Wontumi ye nya adwuma biem o se asem no krampo no etwa ne sunum ama na num aye no nwono o kan a o se asem na eye apia kubidi abeto se oba court abeka kire me judge se chema Wontumi high no na ono judge no oni ho chema Wontumi ne ene ne kekasika asem so obetua le ka a day no per hour no na oni wo no se nde apia kubini chema Wontumi gya adwuma ya aden na waba court abekire mi se na me ni we na ye adwuma na ye den ye nya adwuma bi wo se ene de on de ohu ne se eya asem bia eye bosremuka eya asem bia eni nyina so eya asem bia sebio I to say apia kubi on sheda nim de okeka na ama ono judge kwa nenum ato eno na kasa supplicage ama nenum ato ye dwudwam opa ko bia wo de na wo so ko tuche mu ho se me mabon wo na wo PhD ko me ni PhD me go school kurada enti wo na wo ko school wiase yira ko na ko kirechirem Facebook ye nyisika aboa paragraph 3 ye dwudwam even though the respondent has raised other grounds of objection, the objection is sustainable on only one main ground, which is the application by counsel for leave to withdraw from criminal proceedings is not a function of any rule of procedure nor of settled case law jurisprudence. Kai abba. Osi ewom se asema eye apia kubi de bae no sebio omo a eye atari general mokra so asore etia se asem ne nyina so no o se ono ngasa judge no otena asem no hwa asem na court nsensem mu ne court nyina so no ohu asem bia krampo a onkotwa ho nam emfa metoto ade a apia kubi e kire o se hwede pompo e kire wa motiom because eba court mremu a ohu eye asem ana emra bi kra ontumi nkotwa ho emfa meka asem wanka se wempo de and then it's kakra or say or check ya jurisprudence any brofa kese o you see no or say there appear could be ye no I said the pompo e kire wa botiom na on seda ni asem on seda ntumi nko eye court mrem enhwehwe nkrata mu ehun posa asem bia ba obetumi gina like say okay ye twa asem mi ho kakra e na edidi asem bi o say onhu bi aboa on ti ase mi gidwam ko bia wo dia Facebook yanji ska kwasiato ruling na making ka kire wo no wa mam ska ade a cha wo do kwasia se bedidi otu fu atem ko menhia ne kire mu kire wo. Paragraph 4. Tieniye pa judge ni judgment ni. The instant application is alien. Judge ni say eye krata na apia kubidi aba no. Eye tete extraterrestrial spirits. Honhum bone honhum a ebi ni asase so a de bia na excite omo den tete from aliens emfia sas or say the application is alien or say Nsawam na be hun krata we atro we bi or say the instant application is alien and not a procedural requirement in criminal proceedings or say krata apia kubi di ba ese oni chema Wontumi nye adwuma biem a ono oyejaja omu nyina tekod o se sa krata na otro de beto no eye bosremuka a sebio eye honhum nsem a sebio chese ebi kura ni asase so eye alien ye ka se bibi ye alien a ye nhye dan hwehwe muhu ni gina bie enin gina so ninjina bia ni ho yentumi ntwa asem bi mfa nka sa asem no every say nipa eninjina so and if an alien you cannot at the end of the day prove it. I say asem no aya ni nyenyan it's enunciating and word no you see you know or say it is alien and not a procedural requirement in criminal proceedings or say eba kro no ho nsam keka enchirechire mu ne court ho den nsam a o se saa asam na eye apia kubi ka no I te said the pompo e kire wa motuom engina so enhyeda ni ho so it is antas wa fe wo se brantie de o ya de o aboa me me ya de kwase ampe we abedi matas we de o tu voatem into way a UFO extraterrestrial spirit. Yes. Judge Nukra is shocked. She is amazingly amazed, conspicuously convinced that this despicable application is alienated to the alien level of UFOs. Now, young paragraph 4, I see. Counsel herein does not need leave of this court to withdraw as counsel. Or see, or see, appear kubi. On here, court permission say on the chairman Wontumi be judgment. Court dear, only go sign a contract, na mini ho, na mini ha, court ni ho, chief justice ni ho, judicial service ni ho. Inti embemu krampo say obesola no papi power to about to powder be gina say me chairman Wontumi nye adwuma biem. No, or see emra kura no bia ni wa e kire say e osanko otu sa na mo no. Yanko enim. This is an issue between himself and his client. That is, in this case, the first and third accused persons. Or see, sa semu we ya apia kubi dia be gina quarter or yet say pompo kire wa motuom ogu o samra ne ho je ne ho samra ne no o se sa asem we ono de clearly no enya asem a ye de ba court o se eye between chairman Wontumi akonta mining any apia kubi omonko fie no omonko solve judge ruling ni ende wie onso man kinkan we ankyere mo kwasia 40 Wontumi ne nkwasia Kesbi ne omugimi FM ekekan kwasia asem munti asem no enje nkrantan kinkan. This application is an alien application. Alien application. It's a pure alien application. Now, Okudeni did not say if he chooses by his personal decisions to abandon his client Brofuna judge natural no. Or say if Apia Kubi chooses, if he chooses, one can say if the court chooses, one can say if I the judge or the prosecution, or say if he chooses by his personal decision on one can say pem. So ye na adwene say so or sidi trimu pi na ono ani pem or ye na adwene say obeto eye chairman Wontumi ato atwene e wo kwan so abra make sure eye judgment or say sa ade no at this stage it will not affect the timetable of the proceedings. Or say sa Apia Kubi ankasa firi ni pem oboni na adwene mu pi or hye no ho bo na oye na adwene say baby omodu no obeto chairman Wontumi ato atwene na oni na gya adwuma dia o se eno no ne court de enka ne court na aka ne court skirt o se ne court ne de ebo adwuma ni nyina ne sen ye nyina ye atwen judgment on the 3rd of July. Enti inkura Apia Apia Kubi ene chairman Wontumi ene akontama ne ebo abonten o se enka eye court enka court dwuma dia yedi. In fact, the court does not recognize it. Me catch them last week. Yanko yenim metro baby e ho na enkini wom. Say MPP for you see dodo mo di MPP chi no mo jimi. MPP for no mo enkran na omba ni okumase a na MPP kumase for no twa ho ahia. Ebini frinkran bo ebini frinkran ne rekete ginim omo musansam. Enti dia na nkranfo no ye ne say MPP nkranfo no eye ba omiane ne nkofo no omo ba kumase no mo benne omo benne wo kumase a no be jajandam na to na ye ne eye MPP for the was antibem no ne start group ebini frinkran bo ebini frinkran ebini frinkran bo ebini frinkran bo no mo so ebini frinkran ba omo musansam wan bini nie eduane be no di ye no di gobe ye nim ebini frinkran bo ebini frinkran ye musansam enwan se ebini frinkran ba ni egu ho ni ejimi MPP nti mo jimi o. Now mame ko be ni na mjidwa de akanim ejuma ne ye o hwa akọ hwe o hwe na wadi kuma e simple we menshel miam show miam sika
se wani kuma kokoda se wo hwe na wani nkum so a coalition center na kobo electoral commission for ho ba ye den eman se wani kuma kokoda se wo hwe na wani nkum so a coalition center na kobo electoral commission for ho ba ye den eman se wani kuma kokoda se wo hwe na wani nkum so a coalition center na kobo electoral commission for ho ba ye den eman se wani kuma kokoda se wo hwe na wani nkum so a
ebini frinkran bo ebini frinkran ne abenne no mokọ ne edin agura de hia ne se ebini aba ebini frinkran bo ebini frinkran amini we influence na mensa kakra ah na kete fora ebini frinkran bo ebini frinkran bo ebini frinkran ne atwe ebini frinkran bo enkranfo na benne enkranfo MPP fo na benne okumase ene egu ho wadwa ko bia wo de Facebook ye jiska aboofunu mama dwodwam now over paragraph 5 ebini frinkran wo de mo tatra na monya o Apia Kubi o de cheba o di kosan contract na Ghana ban o na aboofunu the state did not employ you Apia Kubi na yapam wa o ba be ka kire state no e de nkwasa keka no ebini frinkran now mama kind de wase no e ho na ink no wo ye wi a say ye nyankase show about 11 o Ghana nkwasa journalist for no bank kan kire mo motete wona jimi. Paragraph 5 Judge in the ruling or say the application is not competent before the court. Or say application about me. Say competent or say the application is not competent before the court. The judge in the park change and say, Sakrata na appear could be the buyer no. Sebio, where the nanusi so a young quasiansam, a shedda ninja swo, a nyansama, nyansa woman was any partner home, a popo, mu bensen pensemu, a ginin pose, obedi hujuma, or say, the application is not competent. Application no, nyansenim. Eninjina so emfaso ni so entumi say court the time nipa onim de onfa saa ade we emba enti judge no she was being diplomatic about her statement, being politically correct and legally reasonable. She was rationally dissecting the foolishness of Apiakubi in a more matured, deliberate and fantastic way. It uses said the application is not competent before the court. It was say samna Apiakubi dia bano nyansenim but okani Christom yanko enim na minjum okunen was say assuming without admitting that the application were even competent before this court. The court has taken notice that the lawyer seeking to withdraw has not directed service on his own client to enable them appropriately respond. Or say, young fan impo say, or judge is okay. What ye a woman says some of the by Yansen, but young fan say, ye per se, the audio banumpo yabejatum. Appear could be cramponumpo and serve chairman Wontumi officially. And can't say, Minue Jumaye. Just appear could be no, and Quasiadi buga nkurasem. Court and say, ah. What the young fan say, Sanquaja say, we are jatum. Na san the clients now, or no, anti oba court hano. San the clients of Crampo on to me officially and can say, Mo, Minue Jumaye. In his application, he could not state that officially he has, at the end of the day, resigned from being the lawyer of these two clients. So judge says, now one can say work about sign contract. One no client didn't come on, munim dia mobeje, ave muja mo come on break it down. Yenya o quarter be disturb for so ben so. E dia nsem hunu no. The application is not bawomia. So the judge is saying the application is not bawomia, it is not competent. The application from Apia Kubino, it is bawomia, it is not competent. Into say, oh, dear, Yamfan say, Yamfa obuo Emma Apia Kubi. Niankas okay, Apia Kubi. Oh, dear, the other body ajatum. Na, Yapesi Busawu. Sa, aye, in Confona, Ujino, my name war court hano. A chairman won't to be a contaminant. Official impo, what catch on your munyajumabim. Yan Sabienim. Or sing Gina Sonim. A benefit kind. A benefit kind, a benefit kind. Mode de munimans MPP fo abani agu Kumase na MPP fo a mo Kumase na mugu ho ebi ni frinkran ba e na mo che ne se force oh we de we first selection ebi ni na mo che ne first selection mumbu sansam ebi ni we firi he wan dia odi aduane ben he na okodidi munnim de munimans ebi ni frinkran ya kan won kran yan tiase hwe chema wonti bujeli na be ma be Ibrahim beko ejimi fo mon kenkan. I mentioned we are ink in woman. Now over paragraph 6. Pay attention. Let me change this and put you on paragraph 6. Ehono yashada I highlighting no maybe chawa die bi ho. Paragraph 6. Let me read paragraph 6. Ehono abengu say. Sa case na mu simple sa no. MP for you so be ejimi. Now let me read the paragraph 6 eni. I mention idea judge in the tro ho. I mention tro. See. I say consequently, and yet consequently, consequently, and consequences, the consequence, yanka consequences. Me mama chebro for kakrawa ha a Jimmy Fono. It is your choice, yanka, it is your choice, Jimmy. We don't have any choice. We are waiting, and we will see what they will say. Yanka a choice, and your choice. Let them do what they want to do. It is their own choice. A bullful choice. One choice. And your consequence, a consequence. Consequently. Consequently. The O is silent. It should drop in your throat. Consequently. And not consequently. I wonder. We don't know. The consequences, we are here. There are consequences. Are there any consequences? It is their own, they will face the consequences. It is not consequences. It is consequences. Consequences. See, so I'm for consequences. Consequences. And your consequences. And your a choice. 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 It is your choice. It is your choice. And your choice. It is your own choice. It is a party. It is a party or it's a party. And yet it is a party. Yanka party. Party. A party. It is, they are having fun at a party. And yet they are having fun at a party. So it is not choice. It is not consequences. It is not party. And it is also not it is not digitalized. It is not digitalization. It is digitalization. And yet digitalization. And then the digital and digital and yet digitalization. 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 And yet digitalization. Yeah, digitalization. It's one case mumbreme. It say but then some come papa be chori. It put me nya de kitikiti we na some for us go. It's more mumbreme. I don't have mamu. It's some beto eye Shinabon 50,000 boxes to come on papa keke. Enti to me nye. It's one case to mumbreme. One case naturally mumbreme. It's jeme ye. All right. Mumia guy paragraph 6. Yeah, the incompetent applications, the alien application. Ejuma bijaya version before. Emi nyanya yo meche papa. Hey, now mommy uncle the consequences. the consequences. So mommy uncle paragraph 6 that makes you. Now paragraph 6. This is what the judge said. Into my pacho you yatia. You know 2027. I did be now, consequently, since filing of closing addresses is optional and not a function of the rules, that is to say, there is no provision under the rule compelling a lawyer for an accused or prosecution to file an address. But I kind with them you ahana enkene wo. Judge no the ruling or trobibi or say and can be or say consequently, since filing of closing addresses is optional. What is closing addresses? Yeah, there something in area. Let me do a little education here. Now if it is here. Say your court, right? Now your boy in crow in area. Ebi ohwa answer na judge no edin ruling beba no or see oh both councils obia entry the opinion and then your friend no addresses and then your friend no your final address. That opinion judge no say optional. Until right now judge no say on the 3rd of July and audit the judgment beba no any opinion that is put out by both councils, it is just optional. You can choose not to address. You can choose not to share your opinion on the proceedings, how you saw it, and how you see your client's fate. It is optional. It does not really affect judgment. It is judge and it cannot see. And let me read this again. A very important thing maybe I say. Because right now, no, the whole thing has become say, appear could be say, address be also address the court, you know, even though the judge, you know, is writing her final judgment, you know. The address, you know, judge, you know, a ruling, you know, say the address is optional. So address now, either the prosecution or the defense counsel will write to the judge, you know, they are optional. Technically, they are opinions of both counsel. So a council can choose not to address. So, factually, it does not affect the case, the final judgment, because the judge is looking at what is in front of her, not an opinion. The judge is basing her judgment on facts, and facts are what was provided during the cross-examination, the proceedings from the prosecution and the accused. At this point, the judge is basing his judgment on the facts that were provided. But if the prosecution counsel or the accused counsel decide to address, that is optional and also an opinion of the counsel. It is an obi kachira will say, appear could be, I will say or address it. Judge no the judgment, the address is optional. Embrabie nuwa, just address no a chinchini and a chin. And no be determine or a be decide the case. No. You can choose to go through the whole proceedings and decide, say, Mr. Judge, thank you. I don't want to address. I don't want to have my opinion on the whole thing. Write your judgment. A optional. But appear could be the MP before the creativity to Ghana for him say that address plays a very vital role in the judgment. It doesn't. Now, Mamako and Namcho Adebi. Or say, consequently, since filing of closing addresses is optional and not a function of the rules, There's a enim court. You can choose to do it, you can choose to ignore, because it does not affect the matter with evidence. It does not. It's just an opinion. It functions of the rules. That is to say, there is no provision under the rules compelling a lawyer for an accused or prosecution to file an address. Now, Okuren must say, addresses are optional statement made by lawyers to articulate on the merits or demerits on a case one way or the other. Or say, the thing we call addresses are optional statements made by lawyers to articulate on the merit or demerits on a case one way or the other. So basically, your lawyer can choose to address. It is the opinion of your lawyer, because during the address, the lawyer is trying to share his opinion on the whole process. The address does not affect the evidence which was put before the judge. If Apia Kubi decides today not to be the lawyer of Chairman Wontumi, not Chairman Wontumi a new lawyer, and the new lawyer will come in and share an opinion through an address, but the new lawyer cannot affect the facts or evidence the judge is basing her judgment on. Do you understand? Because you need to understand and say the judge is already writing his judgment. Now, if Apia could be say because he has not addressed the court should stop. No, because it is optional. Now, if Atachia is stepping in for Apia Kubia, Atachia can address, and the address is optional. So Atachia cannot halt the judgment the judge is writing, because the addresses cannot affect evidence. Evidence sits on its own. The judge is basing his judgment on the evidence. Addresses are opinions. So Atachia, who is now the new lawyer of Chairman Wontumi, can choose not to address. And he can also choose to address. But the issue is, the bottom line is, he chooses to address. Technically, he will share his opinion on the whole proceedings. And if he wants an opinion on proceedings, he can ask Apia Kubi. Apia Kubi can give him all that happened in court. Apia Kubi can share with him all the proceedings, how evidence were tendered in. Apia Kubi has all the evidence. So Atachia has work to do. He can go to Apia Kubi and take all documentations, read and share his opinion. But he needs to understand, his opinion cannot affect the evidence that has been tendered in, the evidence that the judge is basing his judgment on. Now we'll read the last part of judge's statement now. I'll say, the court would by this extend the time of filing written addresses from the 17th of June 2026 to the 24th of June 2026. Now, Judge say, the address, the opinions, because Apia Kubi, I withdraw the services from Chairman Wontumi, Nanka was say written address on the 17th of June, we Nanka will say you're ready. But Judge say, because Apia Kubi is withdrawing his services, Oma akwesi 24th, meaning it is still within the judgment date. Why? Because addresses are just opinions, meaning Atachia still can address through written opinions, address by writing to the court, share his opinion. So Atachia Ochina, what he can do in the say, Obetuma ko eye appear could be say documents are share court in a former share. Now me share proceedings and I'm share my opinion. They are still within the 3rd of July, meaning the judgment is still valid. The strategy of Eye Apia Kubi and Atachia is to delay the case. But the judge said, if even Eye Opesa or considerator, Nanka on the 17th, Obian Wobetmia submitted written addresses. But I'll say, because of what Apia Kubi is saying, say a new lawyer has come out. The lawyer can still share his opinion because facts, the court have all the proceedings. Fact, Apia Kubi has all the proceedings. So at the end of the day, if Atachia is really ready to be Chairman Wontumi's lawyer, he can go for those things. 1 month more days. Now go say end the 17th or so, end the 24th. And Atachia still has to share his opinion. He can choose not to share. And the judge say, still, the judgment still stays on the 3rd of July 2026. The judge will come out and bring out the judgment of this matter. So what the judge in what the judge was trying to say, then say, Matidia Mokano, but the fact of the case in Yan say, your decisions with your clients, Wontumi, any akonta, it does not affect the evidence I am basing my judgment on. Finito non grata. Atachia can be your lawyer from today. From now to the 24th. If you want your lawyer to share his opinion, he has the right to share his opinion. The documents are there. He can go to Apia Kubi. Apia Kubi can hand over everything to him. He can still go to the court. They have all the documents. He can read through it and share his opinion. But opinions are optional. Addresses are optional. And nobody in Ghana can base judgments on opinions. The judge can only write his judgment based on the evidence Apia Kubi provided and the prosecution also provided. So for the judge, he's working with evidence. Whatever comes after the evidence is just optional. It is just an opinion. And this will be catcher say, Apia Kubi, Ofri Hono, Chairman Wontumi, Akofa Atachia, into a court, and postpone the case, delay taxes. From what I have read, there is no room for anybody to postpone any case. The judge, from what I have read, with all due respect, I don't believe she can postpone any judgment. The judgment still needs to come on the 3rd of July 2026.